Thank you.
That's a good question.
So far. Welcome to the Rapid City Planning Commission meeting, April 9th, 2015. Some housekeeping items. If any member of the audience wishes to speak to an item on the agenda, there are speaker request forms to the left of the dais. Please fill out the request with the agenda number of the item you wish to speak and hand it to the secretary. Cell phones and electronic devices. At this time, we'd like to ask that any member of the audience has a cell phone or other electronic device that you either turn it off or turn the ringer to silence. If you need to take a call, please step out to the hallway so that the meeting will not be disrupted. The consent calendar. Items 1 through 13 have been placed on the consent calendar and may be approved as a group. Action will be taken on all consent items in accordance with staff recommendation by a single vote. Any item may be removed from the consent calendar by a planning commissioner, staff member, audience member for separate consideration at this time. The findings of the planning commission are recommendations to the city council. The city council will make the final decision with the exception of the following items. Item 5, 15 PD 006. Item 6, 15 PD 007. Item 7, 15 UR 007. Item 8, 15 PD 008. The Rapid City Planning Commission actions on these items are final unless a party appeals the decision to the Rapid City Council. All appeals must be submitted in writing to the Planning Commission and Development Services Department by the close of business on the 7th full calendar day following action by the Planning Commission. Are there any items 1 through 13 that staff would like removed? Any items 1 through 13 a Planning Commissioner would like removed? 9 and 13. Okay. Are there any audience member that would like it? I have none requested here. Okay.
Move to approve with exception of
Motion's been made by Steve and seconded by Jan to approve items 1 through 13 with exception of 9 and 13. All those in favor, please say aye.
Aye.
All those opposed? Motion passed. Item number 9.
Thank you. Item number 14 is 15.
9, item
Oh.
number 9.
I'm sorry, I didn't hear that.
Madam Chair, if I just had a couple questions for Carla, and I'm supporting the action on the recommendation, but I just had a couple of questions. Carla, I looked through what you had researched and gave us, to answer these questions, but can you tell me why there's not a maximum amount of hives that can be on a lot, or how you arrived at that? And there's 3 things, and I'll give you all 3 so you can answer them. Why the 15-foot distance, and why the city's not requesting licensing. And the reason I'm asking that is because the examples you gave me show those in other communities, but not in this community. I just am curious to know how you arrived at that.
Thank you, Karen. I worked with some of the beekeepers, hobby beekeepers in town to look at the ordinance as well as receive staff input. There is a limitation in 6.12.040 that there are no more than 4 colonies per lot or tract. So there is a limitation in there. You kind of made me panic. I'm like, I thought it was in there. It is in there. And regarding the licensing, I think there was a concern about just too much regulation of them. Honestly, I've been told, and I know there's some beekeepers in the room, that within the city limits, there's maybe 100 of these sorts of hives that have been in existence for some time without any regulation and or without any oversight from the city. This did come to our attention because of a complaint, but we haven't received, to my knowledge, that's the only complaint received in recent memory. And so given that history, given the fact that the beekeepers do need to register with the state, the location of the hive with the state, and just there was just a decision made not to include a license requirement in this proposed ordinance. That may be added by the council, when the council looks at Title VI, but that's where that came from as of now. And I forgot your third question.
The third one was about the 15-foot distance.
Oh, I think that was a compromise. I think the beekeepers would like it to be less. I think the ordinances that I reviewed had it to be larger. So staff concluded that 15 was a good distance.
Okay, thanks, Carla. I must have missed that part about the maximum of 4. There was another section in there that said if you had a certain 25-foot distance, then you could have an unlimited number. Is that correct? So those are for larger lots, I would assume, then.
Right. It says a normal tract or can't have more than 4 colonies on any parcel, but if the size of the lot permits all hives to be located at least 200 feet from the property lines, then there isn't a limit. So that would be a much larger lot.
That must have been what caught my eye or something. Okay, thanks, Carla. That answers my question.
Yes.
And I will move approval of that item.
Motion's been made and seconded for item number 9. All those in favor, please say aye. Aye. Opposed? Motion passed. Item number 13.
Madam Chair,
Yes.
I can ask that question there too. And this again is for Carla also. Sorry, Carla. This is the item that talks about the Zoning Board of Adjustment rules or bylaws. And I had a couple questions on that. There was a section in there that under Section 5 talks about 3 votes in favor of any appeal. And I understand the reasoning for that because you at one point I understand you have to have 4 to make a vote for yes. And to me that section, it just reading it from a layman's point of view, it just sort of pops out and says 3 votes in favor of any appeal shall be deemed a denial. it just sounded like, well, what makes it an approval? And I didn't know if there's something else in there that I missed that showed that, I know a quorum makes an approval, but if you have 9 people, that would be 5 if all showed up. But you're saying that if there's only 4 people and 3 people vote for it, that still does not make it an approved thing. And I just wonder if there's a way to clarify that a little bit more to make it seem so that the public understands what that means. Am I getting that across right?
Yeah, the section that you pointed out is Article 5, Section 5, and that is not something that I overlooked changing when I was making these amendments. And just to be clear, this is before you, not for a vote on the amendments, but because we need to give notice of a change in the bylaws at least 2 weeks in advance. Karen, you pointed out something that needs to be changed in light of the adjustment of the numbers, and I can clarify it and say that, 6 votes are needed on the zoning board as it is constructed, or will be constructed next month, in order to approve any appeal. And I can make that change and have that when it comes before you for a vote.
Great, that would help that. I also wondered if there's a place in Article 8, I think it is, in there something that would say that the Zoning Board of Adjustment has the same time frame as the Planning Commission. We have a 3-year term, but I didn't see a term in this for Zoning Board of Adjustment, and I thought maybe it should be concurrent with the Planning Commission or state that. I know that we follow the same basic number and that kind of thing, but I didn't know if we should clarify that so that people knows that the Zoning Board also has a 3-year concurrent term.
No, I think that's a good addition. I'll make that change.
Okay.
Yeah.
Then I have one other question, and this is just in general. If the Zoning Board of Adjustment goes past 7:30 and Planning Commission's at 7:30, how do we do that? Do we stop the Zoning Board or extend that and just say we're delaying the Planning Commission? And we can do that?
I would finish the zoning board meeting and just say we're delaying the planning commission
Okay.
meeting until the other meeting is over.
Okay.
Yeah.
That answers that. Thank you.
Okay.
I'll move approval of that item.
Vicki?
Just a point of clarification, there's no set time for Planning Commission. Planning Commission will directly follow Zoning Board of Adjustment, and that's how we'll advertise it, and that's what we'll notify the applicants. So it'll always be whenever it's over. If it's over at 7:10, or if there's no items, Planning Commission would start immediately at 7.
Oh, I thought there was something in the Planning Commission ordinance that said Planning Commission would start at 7:30 in the items that I read.
We will make sure that it's to directly follow so that we're not having downtime between Zoning Board of Adjustment and Planning Commission. That you can
Okay.
start directly after. Thank you.
Okay, thanks.
Thanks. Motion's been made and seconded by Jan to approve item number 13. All those in favor, please say aye. Aye. Opposed? Motion passed. Yes. Okay. Yes. With the amendments. Thank you. I now would like, before we start the consent calendar, I kind of waited till everyone was in, but I would like to thank Tim Rose for his service on the Planning Commission. He's resigned, and we now have Galen Hogestraat, and we welcome him to the commission. And this is his first meeting, so I'm sure he'll find it very enjoyable. Consent calendar, item number 14.
Thank you. Item number 14 is 15P004, a major amendment to the plan development to allow professional offices on approximately 0.56 acres of property located at 329 Main Street. This is the existing location of the Tires, Mufflers, and Alignment building. The applicant is proposing to create offices that will function as flexible workspace solutions that will basically allow professionals to rent out office space or the amenities associated with offices on an as-needed basis. Parking for the offices is going to be located on the lot adjacent to the east. I'll show you in our slides here in a moment. As a part of this application, the applicant has requested a reduction in parking from 51 spaces to 28 spaces. Let me take you through some slides. You can see the location of the property is adjacent to the Central Business District and General Commercial District to the north, south, and east. Aerial shot of the property, you can see the properties on the east side there are the existing parking lot. The parking lot is paved, and you'll see that shortly. There's a potential site layout for the parking lot and the office structure. I should take the time to point out here that it does indicate on the site plan that a future brewery may be included in the future, but that is not a part of the approval today. And if they were to bring in a brewery in the future, it would require another major amendment to the plan development, and it would be brought before you for your consideration. You can see the parking lot adjacent to the east. It's providing 28 spaces. The applicant has indicated that based on the nature of this use and their experience in other communities, the reduction in parking would still provide enough adequate parking for the uses on the property. And we should point out too that the surrounding area, as you'll see, the on-street parking located in the surrounding area it doesn't appear to be overtaxed during the day. So, here's the sign located on the property. A look at West Main Street looking towards the east. West Main Street looking towards the west. And 4th Street looking south. The cars that you see there are part of the TMA. They're not their stock, but the cars that they're working on currently. And the existing parking lot. One more view of the building. Based on the applicant's experience with these types of workspace solutions in the past, and as well as the existing parking in the area, staff believes that the reduction in parking can be supported. Staff also recommends that the request for the major amendment to the plan development be approved with the stipulations outlined in the staff report. Staff is available for questions at this time, as well as the applicant.
Are there any questions? I'd entertain a motion.
Move to approve.
Motion's been made by Steve and seconded by Eric to approve with stipulations. All those in favor, please say aye.
Aye.
Opposed? Motion passed. Item number 15.
Item number 15 is a final plan development to allow an on-sale liquor establishment in conjunction with a restaurant. Restaurant is to be the Native New Yorker Grill and Wings, and I'll take you through some slides. It's located out at the Rushmore Crossing development, and the recently saw a plan development on the corner with Eglin and East North Street for a gas station. This will be located west of that. Property zone general commercial district, as are the properties to the north, south, east, and west. Currently, the property is void of any structural development. Applicant's proposing a 5,408 square foot restaurant with a 605 square foot patio. Here's some elevations of what the building fits in with what's currently out there at Rushmore Crossing. Sample elevations. The applicant is not requesting any exceptions to the minimum requirements of the area regulations. Property is located on Eglin Street, Collector Street on the city's major street plan. This is a major commercial corridor in the city, and the on-sale use will be in conjunction with a restaurant, and that's how the stipulation of approval is written. Here's looking at the property, looking north, looking towards the intersection with East North Street, and to the west along Eglin Street. And these are properties to the south, also in Rushmore Crossing. Staff recommends that the final plan development be approved with the stipulations as noted in the staff report.
Motion's been made by Steve and seconded by Karen to approve with stipulations.
Madam Chair, I'll be abstaining from this item.
Okay. Andy will be abstaining. All those in favor, please say aye.
Aye.
Opposed? Motion passed.
Madam Chair, if we could take items 16 and 17 together.
Please.
They are a preliminary subdivision plan to create 26 townhome lots and 6 single-family lots, and a rezone to low-density residential 1 to low-density residential 2 on the western portion of the property. And with that, I'd like to show you some slides. The property that's shown in the black rectangle is the site that we're discussing today. It's a little over 7 acres. The area that's being proposed for rezone is the part that's shown in yellow. That's about 4.9 acres. The orange portion is currently medium-density residential. We did do some calculations on density. There's an email that's sitting on the dais from a John Swanson who lives in the area, and he brought forward a lot of good concerns and things that we looked at as we were reviewing this item. We had looked at potential development of this site over the years, and noting that portions of this property are currently zoned medium-density residential, there was some discussion in the past of potentially apartments in this area. For the acreage that's shown in orange, they could put in 58 units. When we saw this proposal come forward that would allow townhomes and single-family, certainly we saw this as an improvement. One of Mr. Swanson's comments is in relationship to density, is the 32 dwelling units appropriate for low-density residential? Well, if you do the calculations at 6.7 dwelling units per acre, they could put in a total of 46. So even that is above what they are proposing. The site is currently void of any structural development. You can see it's just off of the eastern terminus of Hofer Avenue. Their intent is to extend a cul-de-sac street 800 feet from Hofer Avenue. That cul-de-sac is a length of 800 feet, and it would serve 32 dwelling units. Our current infrastructure design criteria manual states that a cul-de-sac street cannot serve more than 20 dwelling units or be more than 600 feet without an intermediate turnaround. They sought an exception for that, and it was granted with the stipulation that each of the residential structures be fire sprinklered, and you'll see that as one of the stipulations. We worked closely with the fire department. Certainly anytime we can get those residential structures sprinklered, that's a benefit for the community as a whole and certainly for the neighborhood. Looking at some of the topography of the area, if you look at the arrows, you can see their conceptual drainage plan. It's very steep at the north end. Showing you some of these site plans, you'll see more of what I just mentioned. This is looking north on Churchill Street, west on Hofer Avenue, into the site, and you can kind of see a rough where people have been driving into the site. And it's the properties to the north where you can see that there is a significant drop-off into this site. This is at the very western portion of the property. That drop-off is a little more gradual at this end. And then as we just kind of go down towards the east, you can see that it's extended. A part of what we have is a conceptual plan with the preliminary subdivision plan is acknowledgement that they will be constructing a retaining wall to secure those soils and to address some of the drainage. If that final design comes in higher than 4 feet, it must be designed by a professional engineer. That would come in with the construction plans that's administratively reviewed by staff. Ted Johnson with the engineering division has been closely working with the consultant who's here in the audience today. And we have noted that there are drainage concerns in this area. And certainly what happens on this site must address that. We tried to craft a stipulation very carefully so that it appeased the concerns of the neighborhood as well as requirements set forth by the design criteria manual. And you'll see that in stipulation number 4. And it's basically stating that they shall maintain off-site runoff, because there is drainage coming into this site, at historic water quality levels without adversely impacting adjacent properties. So we have taken that into acknowledgement, and we will see that being addressed as a part of the construction plans. Looking to the southeast, you can see the property south of this is currently undeveloped as well, and then more to the south. Having noted that this is an area that has been reviewed over the years for development, and citing that the combination of townhomes and single family seems to be a density that's appropriate for the existing street sections that are there, Churchill and Hofer currently are designed to local street standards and should accommodate the traffic that would be generated by this. So staff is in support of these two items. We recommend that they both be approved with the stipulations as identified in the staff report. If you have any questions, I'm here to answer them, and we do have the consultant in the audience as well.
We'll make the motion and we'll give the questions. Someone want to make a motion?
Move to approve with stipulations.
A motion's been made and seconded. Any comments? Andy?
Thank you, Madam Chair. Vicki, I think you may have answered this, but I'm going to ask the question again. So part of this existing plot is low-density residential, and part of it is medium density. What would, if they were to stay those two zoning as they currently are, what would the density be? What would the number of units? You'd be able X amount on the acreage of medium and X on the low. What would that equivalent be?
Well, all the calculations I did last night. So we have 58 that would be allowed on the medium-density residential,
On that little piece?
on that little piece.
Okay.
And we would have 46 total if the entire thing was at 6.7 DU. So you probably could put another 25 units, so 58 and 25 is 83.
So maybe we be, excuse me, 20 on, just simple math, 20 on the existing low density, 58 on the medium density, so a total could be 78.
78.
Okay, and we're at 32.
Exactly.
Okay, thank you.
And just for a point of clarification, this is not a planned development, but this is a plat in addition to the rezone. So once this plat goes forward, it will secure that configuration, thereby dictating the use of the site.
Yeah, and what's leading to my question is showing that as a combination, we're giving up a little bit of density or gaining some density on one portion, but we're actually decreasing on the overall piece.
Completely.
So when you look at it as a whole, appears to me that's more beneficial for the overall neighborhood. Thank you.
Any other comments? Dennis?
Would you go into the retaining wall? Again, you said something about if it is a 4-foot structure, well, if it isn't. And what I'm concerned about is future individuals purchasing property there and whether or not they will have a lot of water coming into their structures.
Dennis, if you don't mind, I think I'll refer that question to Ted Johnson.
Actually, I'd refer that to the consultant. But in general, the retaining wall, the requirements for the retaining wall is if it's above 4 foot, it has to have a structural design, be designed by a licensed engineer for stability, look at soils, look at the drainage information. So below that, you still have to look at the drainage, have to, provide the site improvements. Just the actual design for the wall is a little less stringent for the shorter levels and just for the structural stability. But I guess as far as the walls and drainage combined, I'd refer you to Ron Bangs, the applicant's consultant, for a little more information on the drainage patterns.
And Madam Chair, if I might also add, that in addition to the retaining wall being a part of this design, there will be a final grading plan and erosion and sediment control plan that would be submitted with those construction plans, all which go towards the stability of the soils and addressing the drainage.
Thank you, Vicki.
Good morning, members of the board. Ron Bangs, Advanced Engineering. Excuse me, fighting a cough. To address your two questions, the retaining wall is currently in the preliminary grading plan in front of you. The retaining walls are above 4 feet. There will be soils evaluation by a geotechnical engineer, drilling on site, and a structural engineer will design those walls. I think right now what we're looking at is between a 6 and an 8 foot wall. We've got walls currently identified in the northeast corner, which is the steepest, one of the steepest areas, and in the southeast corner, near the, I believe they're multifamily townhomes to the south of there, and that is primarily to do some grading so we can keep additional runoff and drainage out of those townhomes. We realize there's a problem with those townhomes. The topography slopes to the townhomes, and we're trying to correct that with the drainage plan that we've got and that retaining wall. Drainage, we have not done full drainage calcs yet, as this is a preliminary submittal. With the stipulations that you have in front of you, there's a full drainage report that will be done. We realize the north slope on that lot is significant and it's steep. We will look at the drainage and calculate all the drainage. We have met with Craig, one of the landowners. He lives on the middle of Park Hill Street. He is one of the steeper lots toward the east end. We have met with him, walked the site, looked at his concerns, and gotten input from him. We will look at that. The drainage coming off those upper lots on the north, on the south side of Park Hill Drive, that water runs onto our site, and we will have to accommodate those flows. There's no other way for those flows to go. So you will see some changes to that drainage plan as we talk to owners, and we do a full-blown drainage report that will come back to staff for review, and you will see the final full construction plans prior to approval of that final. But that drainage will have to be maintained and taken care of and dealt with on our design.
Thank you very much. I was more concerned about that if it was over 4 foot, so the if element was of concern. But if it's going to be in the 6 to 8 feet, and if you have all of those other future studies coming yet, I think that satisfies me. Thank you.
Thank you. Any other comments? Motion's been made. All those in favor, please say aye. Aye. Opposed? Motion passed. Item number 18.
Item number 18 is a conditional use permit to allow an on-sale liquor establishment in conjunction with a commercial office building. Property is located at 402 St. Joseph Street. It's a historic structure called the Garage. As you can see, it's zoned Central Business District. We just looked at a different application on the northeast corner of this. What's changed in the staff report since the last time we met is that the applicant has indicated that the events that they hold, which are social gatherings, art shows, and speaker events, will take place on Friday, Saturday, and Tuesday evenings. The applicant is proposing that at these events, which don't happen very often, that maybe once a month, that they want to serve wine and beer to the people who are showing up. And I believe they are currently holding these events without the on-sale use. Staff is recommending that the conditional use permit be approved with the stipulations as noted in the staff report, but I'll take you through a few more slides. Property is currently fully developed with structure. Central business districts, there's no additional parking required or landscaping. Here are some views submitted by the applicant of the interior of the space. It's currently used as open office space. Applicant's submittal of elevations. Floor plan showing in yellow the area which will be used for, which is used for events and which will be used for the on-sale events. And these are elevations. This looking to the north, we've got Trinity Lutheran Church and the Echo Prayer Park located on the south side of St. Joseph Street. This looking to the north, looking west along St. Joe. The property right adjacent to the west, currently vacant. Looking to the east, the properties on the other side of the street. And the courthouse is kitty-cornered from this location. The stipulations of approval ensure that the proposed use is in conjunction with an office building for speaker events, social gatherings, and art shows. Staff's recommendation is to approve with stipulations.
Motion's been made by Andy and seconded by Eric to approve. All those in favor, please say aye. Oh, Karen, I didn't see your light. Excuse me, Karen.
Sorry. Thanks. I just wanted to make a comment to Mr. Anderson out there. If for some reason this becomes real successful and you have some people that want to use the Eco Park across the street for things not alcoholic, obviously, but for other things, I think the church would be very welcome to visit with you about that. So I just wanted to make that comment.
I already visited with them last week.
Thank you. All right.
Thanks, Karen. All those in favor, please say aye.
Aye.
Opposed? Motion passed. Item number 19.
Thank you. Item number 19 is 15 UR 006, a conditional use permit to replace an off-premise sign on approximately 0.35 acres of property located at 3425 Sturgis Road. The existing off-premise sign is a static, two-sided billboard totaling 250 square feet per side of advertising space, and the applicant is proposing to replace the existing static sign with a light-emitting diode or LED digital billboard. As a part of the request, the applicant is proposing to lower the sign to 30 feet in height, which is in compliance with the requirements of the Rapid City Municipal Code. The nearest off-premise sign is approximately 325 feet to the southeast, and the square footage of the sign will remain at 250 square feet per side. Before I get into the slides, I'd like to take a moment to present a little history on signage in Rapid City. 2011, Scenic Rapid City, members of which are here today, proposed 2 citizen-initiated ordinances for the public to vote on. The one that's concerning this sign is was called the Citizens Billboard Control Initiative, which limited new construction of digital or electronic off-premise signage. In June 2011, city election was held and the initiative passed with 65% of the vote. Shortly thereafter, Lamar Advertising of South Dakota filed suit against the city in U.S. District Court for contesting both of the initiatives that were passed, contending specifically in this instance that the initiative unreasonably regulated outdoor advertising. The court ruled in favor of Lamar and concluded that the initiative conflicted with state law. So as a result, the court held the initiative invalid, and to date, the city has not determined whether or not this ruling would be appealed. So pending determination of this matter from the Rapid City Attorney's Office, the sign ordinance has not been amended to remove that portion of the ordinance which prohibits electronic signage. In the meantime, until the city has a decision which upholds the digital billboard ban, the city cannot enforce the initiative. So with that in mind, the city did take the application to allow an off-premise sign to be replaced with an electronic billboard, and accepted the application for review. Let's go through some slides. Location of the sign, approximately 870 feet northwest of the intersection of Sturgis Road and West Main Street, at property zone general commercial district. Aerial view of the property. The location of the sign is right there. The existing sign, the location of the proposed sign is not changing. It will remain at the same location, just be lowered in height, and the sign faces will be altered. Look at the elevations for the sign, specifically right here. A view of the site plan. Like I said, the sign is not proposing to change. The site photo shows the location of the sign, as well as the conditional use permit notification sign posted on the property. This is a look to the south and east towards Skyline. A look to the north and west. Give me a moment. This is the nearest off-premise sign. And look facing the other direction, This sign also is an off-premise sign, although it's also serving as an on-premise sign for Family Thrift Center. A look at the digital, or the sign in question. Currently, the sign stands about 42 feet tall. The applicant is proposing to lower that sign to 30 feet. 30 feet is in compliance with the requirements of the Rapid City Sign Code. And I should also note that currently the sign face stands at 250 square feet, and the size of the sign will not be changing as a part of this request. And a look from the opposite direction. The city took a lot of time and effort in examining this and reviewing the court history. The city planning worked extensively with the city attorney's office, the results of which are the memo which was linked for your consideration prior to this meeting. Rapid City regulation states that if an off-premise sign meets all the requirements of the Rapid City Code, with the exception of spacing, then the sign may be replaced, altered, or improved. With that in mind, that's what the applicant is doing here today. Given the fact that the court decision does not allow a ban on digital billboards at this time, the applicant is acting within the requirements of the Rapid City Municipal Code. As a result of that, staff is recommending that this application be approved with the stipulations outlined in the staff report. We have representatives from Scenic Rapid City here to discuss their concerns with this, and we have some representatives from Epic Signs, the applicant, to answer any questions if you have them. Staff is available for questions at this time.
Vicki?
Thank you, Madam Chair. So as we look at this off-premise sign, it's a billboard and it's going to be an electronic digital sign. We applied the criteria for any other off-premise sign, and that criteria is noted extensively in the staff report. It goes to the design, the lighting, the location against an arterial street. Is it in a commercial corridor? So as you reviewed that, noting that that's what we have to look at to determine is this the appropriate location, we tried to address all of that so that when we brought this recommendation forward, we did so with stipulations to ensure that once this LED sign is in place, it must continue to abide by the requirements of the sign code along this arterial street in a commercial corridor. We took into consideration that there is residential farther to the west. There is a differential in elevation. That site is lower. And driving out there and looking at it, you can kind of see through the homes, and yes, you can see this sign. It's similar to the billboard that's out on La Crosse Street, where you've got residential farther to the west. We are not aware of any complaints from those residences so long as the sign maintains the lighting and the other design criteria set forth by code. So as you look at our stipulations of approval, we've tried to ensure that the criteria was being met. If you have any questions for us, and we encourage you to take comment from the public.
Thank you. Someone like a motion? And we'll take comment. Second. Motion's been made and seconded to approve. Now we'll take public comment. Kathy Calhoun?
Hi.
And I will...
Somebody else speak first?
Who?
Okay.
I will say that the way we take comments at the Planning Commission is that each speaker will speak to different issues. So if someone spoke to an issue, then the next person doesn't, because we do listen very carefully. So thank you, Kathy, and welcome. If you'll
Hello.
identify yourself.
I'm Kathy Calhoun, and I'm going to speak. I don't know what I'm speaking. I'm just going to speak first. In the current sign code, there's no current accommodation for changing an existing off-premise static sign to an on-premise digital sign. It was previously not allowed in our code. The intent was to keep from happening what you are about to begin here. If you allow this conditional use permit to be approved as is, the citizens spoke when they did not want the city to be inundated with digital signs. The city is still allowed to regulate, not ban, but regulate the numbers in a reasonable manner. I believe there's an issue with allowing the current non-conforming sign to be changed into another non-conforming sign. As this process continues, why would we even need a sign code? Every company could avoid the sign code by putting up non-conforming signs to non-conforming signs by changing them. With the outcome of the suit and the lack of a current code, this allows 400 static signs within the city to be changed into digital. And is this what you really want? Do you really want our state or city to be, all of the static signs to be changed into digital? There's nothing to stop that this is the precedent that you're setting right here. If yes, then vote to allow the conditional use permit. If not, please delay this ruling until such time as the sign code can be changed to bring it in line with the new rulings from the court. I know that the Planning Commission may not like that, or the Planning Board may not like that, but I just think that's the way to go, because the sign code was not written in line with digital signs being on every corner. It was not written, it was written in thinking that there would be no digital signs. So the code as it stands right now does not really meet the idea of having a digital sign on each corner. Anyway, there are things that which may preclude this particular sign from being changed into digital due to the impact of the surrounding community on this sign. Does it meet the regulations for having an LED lighting sign near the neighborhoods? And they alluded to the fact that there are neighborhoods to the west and that the lighting would be different than it would be for a static sign. I recognize that the code states that spacing need not be an issue. However, this is not really a spacing issue between signs, but rather the impact that lighting would have on the neighborhood. Digital is a different animal than a static sign that's currently there. And the city needs an enforceable plan and updated codes to match the new court rulings, in my opinion. This revision, in my view, should be done before any conditional use permit is granted. This revision should be immediately begun and move through the process with haste. It seems unfair for the sign companies to continue to wait endlessly for our city to determine ordinances with which they can comply. These companies are not our enemy. We want to work with them. However, waiting until the court case is completely settled seems like it would be an essential item. There are other items on the court case that need to be reconciled before we go forward. There are many parts of the current code which were put into place without consideration of how changing all static billboards into digital billboards would impact the city as a whole, and neighborhoods in particular. We have always been told that we could regulate outdoor advertising in our city. Things such as size, spacing, height, lighting, blinking, moving messages, and construction were some of the things we could regulate. So even with the current regulations from the court, we still can set standards for the regulation of the digital signs. Where do we want them? How many per capita do we want for our city? How do we continue to make them non-distracting for our community? Should they be placed further back than from other static signs? There are many issues that need to be worked out in relation to the new information from the court. I would hope you delay this ruling until some of these decisions are made. And one last thing I think should be a stipulation on any conditional use permit that you make is that any company that gets a conditional use permit should have to make sure that all of their signs that they have in our city comply with the current code. No video, no movement. They should be static sign to static sign, 6 seconds in between. Thank you.
Thank you. Deborah Jensen.
Good morning, Chairman Marchand and members of the Planning Commission. My name is Deborah Jensen. And as was just mentioned, just a few years ago, Rapid Cityans overwhelmingly approved 2 billboard initiatives after the city reached the tipping point of about 400 static billboard faces and a dozen digital billboards, more than the city of Denver. The citizens then said enough was enough, and now a precedent is about to be set for more and bigger digital billboards if this permit is approved. I know the city planning and legal department spent many hours researching and studying this permit request. They worked through inconsistencies and apparent contradictions of the sign code. And I have great respect for these folks, and I know they too want what is best for Rapid City. However, more consideration needs to be made for the safety, the aesthetics, and the precedents if the permit is approved. The citizens of Rapid City voted for reasonable billboard spacing of 1,500 feet. Although the sign code exempts current billboards, this billboard is just 325 feet from another billboard. They were too close years ago. Installing an oversized digital billboard will not fix this problem. It's only going to make it worse. City staff noted in their review that this billboard will not increase the density of off-premise signs. In fact, it increases the density of messages by tenfold. A new message changing every 6 or 8 seconds, all day long, all night long. The sign code stipulates that the light cannot be a nuisance to adjoining properties and residents in the area, and staff is relying on topographical differences to conclude that the billboard will not impact the neighborhood. The size of the billboard and the light that it will emit 24 hours a day, every day, may in fact be a nuisance to the residents and the businesses. The billboard is also near a very confusing and busy intersection, which we've all been involved in, especially during school times. We ask that you delay action until additional study, discussion, and vetting can be finished, and until after Federal Judge Viken has made his ruling on the matter of spacing. If you choose to proceed today, please include the following stipulations to those that are already recommended by the staff. Require the applicant to keep the billboard face no larger than 250 square feet. A 288 square foot sign face would set a precedence for the dozens and dozens of other billboards expected to be converted to digital in the very near future. It's also important to stipulate that code enforcement conduct a periodic check and report non-compliance issues. You know, great views, clean air, starry nights, they are all important to every one of us. The decision you make today will in fact impact all of us forever, because once up, this billboard will never, ever come down. Thank you.
Yeah. Mike Wasney.
Thank you for your time today. My name is Mike Kwasny. I'm representing citizens of Rapid City. You know, we live in an area here where we go out at night and we look for the stars. We hope to not take that away, and we're on a road right now to where we may not be able to turn around. We're at an impasse. Not all things have been decided, as was suggested maybe. There are still a few things as far as distance that are being considered in the lawsuit. We have not rewritten our codes to the point where they allow for what's coming. I would ask you to consider, as you go out tonight and you look up, do you want to see the stars, or do you want to see a flashing billboard in front of you? That's our challenge today. Is we live in a beautiful area close to Mount Rushmore, the Black Hills. We do not want to be Vegas. Thank you for your time.
Thank you. Jim Peterson.
Good morning, folks. Jim Peterson. This morning, when you consider this proposal, you need to keep it in context. I mean, I appreciate where planning is coming from. They have a very objective set of criteria that they look at. And Rob, who actually authored this report in front of you, doesn't have the advantage of corporate memory. He just came on board 4 years ago when the billboard wars were just concluding. So what I'm saying to you is this, that when planning decides what impact a project is going to have on a neighborhood, by statute, they send out some letters, 5 or 10 or 12 or how many other people, whatever number of people they think might be affected. But the issue is totally different with billboards, because billboards affect everybody in this community. They take away the view shed from everybody. They decrease the traffic safety of everybody by distracting them from their driving. And so how many letters do you send out? How about 7,000, because that's how many people stood up and said to you 4 years ago that they didn't want any more digital billboards in their community. None. So what happens? What happened historically? Well, I'll tell you what happened. We have our city attorney and Vern Goodso, who we hired, and they go toe-to-toe with an army of Gucci-shoed, Armani-suited lawyers from Baton Rouge, Louisiana, who work for the biggest or the third biggest outdoor advertising company on the planet with billions of dollars in revenue, who come into our community and tell us what our community is going to look like. So that's the situation we find ourselves in. And because of one word, because we picked one word, the wrong word, prohibit, Judge Viken said, well, you can't prohibit. You can't prohibit, but you can regulate. You can regulate the heck out of this. You can decide what your community is going to look like. And that's what you folks need to do. You need to keep this in context. You need to keep it in the context of the citizens of the community who you work for have told you what they want their community to look like. They don't want it to look like Las Vegas. So we need some time. The city attorney needs some time to put a new statute in place. Right now, we have no statute because it was gutted by, at least as far as digitals are concerned, by Judge Viken. And that gutted a lot more of the code because the code, as Kathy said, is based specifically on the concept of we're not going to have any digitals, so we don't have to regulate anything else relative to that. So we need to address the code. We need to put a code in place that's going to say how we're going to go forward from this point. That's what we need to do. And so to jump on this now in the middle of the lawsuit, I mean, the lawsuit hasn't even been settled. You know, there's still major issues like spacing, for instance. And that's a perfect example. This is a non-conforming sign. It's 325 feet from the nearest billboard, not much further than the one across the street. 325 feet. The current code says 1,500 feet. That's one of the issues in front of Judge Viken as we speak, or at least it's going to be relitigated. And so we need to figure that out, for example. So historically, why would we, and we haven't, allowed a non-conforming sign to be replaced by another non-conforming sign? I mean, that's stupid. Why, if Epic wants to put up a digital billboard, why don't they take a conforming sign someplace and put up a digital there? And a reason, I think, is because of this legislation in front of them. They don't know how this is going to come out as far as the spacing. We don't know how it's going to come out. Well, and you don't know how it's going to come out. We need to wait for this to be resolved. And it's reasonable for the city of Rapid City to say, we're going to wait until the jury is in and we know how everything is legislated before we change our code. And we're going to change that code to reflect the wishes of our community, the community we serve. So you need to keep that in context. And like everybody said here, once you let this happen, there is no reason why every single static billboard in this sign, any one of them could be changed to digital, not one. So consider that. And I would suggest that you put this on hold until we get a code we can work with. Thank you.
Thank you. Lisa Modrick.
Thank you, Madam Chair, and for the Planning Commission for listening to us as Scenic Rapid City, as well as the citizens of Rapid City who have been working through this and on the issue of outdoor advertising and what would be good outdoor advertising as against what we are faced with today, which is a tremendous amount of overabundance of advertising that has hit us and hit our community from the entrances of our beautiful city of Rapid City, which has, by way of not having good regulation, has absolutely destroyed the welcome sign of this community, to what we have inside of our community. And that is why the people spoke, and they spoke in an electoral way when certain regulations, reasonable or otherwise, could not be pulled together from previous city councils. And these city council meetings have been faced with this, and planning commissions have been faced with this for decades. This isn't a matter that started 4 years ago, 6 years ago, 8 years ago. If you go back and you even just do a search, whether it's through rcgov.org or anything on the web, you're going to find that there's been resolution after resolution after resolution. You also have before you a comprehensive plan that puts our community into the future. And it's a very exciting plan, and I've read it, I've enjoyed the plan, and this is where where you are, as you are our future. And even in that, it states how it addresses the fact that there is some areas that we need to make sure we find good, reasonable balance. So certainly on a Scenic Rapid City side, we've never been a banning of signs. We're business owners and managers and property owners, and we believe in advertising and good signage in order to make good business. But we also need good relationships between the two, and we need that to be solid. And as stated before, because I don't want to repeat, but the statements that have been stated by the citizens before you really put it back into your hands on the important job that you have today. Does something need to be moved today while there are still things being decided on? While we have a sign code that's written, rewritten, and rewritten, but now on hold, and there's still additional challenges, perhaps even amendments to be had on that. So is today the right day to proceed forward with this precedence? Because what you do today, as stated before, is going to follow you and could really put a tough time ahead of you in your future generations on where we're going to be on our signage. This does have signs in a neighborhood location. It's in the, when you drive by, you're going to see the neighborhood there. That is definitely an issue. I also noticed, I had forgotten I'd forgotten about this, but there's also a for sale sign. So there's a future development opportunity there on land that hasn't been developed on. So is this the time to do this conditional use permit on something that could be coming forward and providing a good economic growth for the city in that particular area as well? So we hope that you can find the right place to go forward on this and to look at these challenges. I do need to say that the company that is before you, Epic, is in current violation, and so does that mean that this company that doesn't run their digitals now in code should be granted another digital? They run full motion. We all know it. We all see it. At some point, we need to code enforce it. Unfortunately, code enforcement doesn't have the funds. You probably are aware of that. It's one of their biggest challenges. They can barely even operate part-time in order to put these signs in regulation when it's a full-time job. It's another challenge to you. We need to put more money in their bank so we can get these signs in line. We thank you, and we appreciate your work and your decision and what you do for our community to put our future in balance and in beautification.
Thank you. Mike Sabins.
Good morning. My name is Mike Sabers, and I'm an attorney here in Rapid City, South Dakota, and I'm the attorney for Epic Outdoor. And unfortunately, I was looking inside of my suit, and it was made at JCPenney, and my boots aren't Gucci. They were also made here. So I'm not apparently one of the Army. What I know is this. I read the letter that Ms. Cushman, the deputy city attorney, wrote to the board earlier this week, and I think it was very well written. The points that she makes are very clear. Scenic Rapid City came forward and they submitted ordinances which became the law. This application is 100% in compliance with the ordinances that these folks proposed to the city. I'll provide a little bit of my own history. When the original ban came forward, I wrote to the former city attorney, Jason Green, a law school classmate of mine, and I told Jason, it doesn't take someone who went to law school to know that the statutes prevent you from banning billboards. And the city's going to get sued and you're going to lose. And we're going to spend a ton of money doing it. We're going to have to hire a whole pile of lawyers. So let's take care of it now. It wasn't. What Scenic Rapid City is basically asking this board to do is to ignore a federal district court judge order on a very simple and straightforward issue. And you don't have to take that from me. You can take it from the deputy city attorney who told you just that in a letter this week. This board is in 100% compliance with the existing sign code. And it should be approved as the city attorney's office has recommended. And the city was led down a bit of a difficult path into a lawsuit that it lost. We spent a whole lot of money. That could have been avoided. The same folks who stand up today are the same folks who got the city sued, and they lost, and we lost. And I would recommend that you follow the advice of the city attorney's office that says this is in 100% compliance and should be passed. And I would answer any questions that any of you have, but I would also appreciate that you consider what your attorney, the city attorney, has told you. Thank you very much.
Thank you. Jan?
Hi. Yeah, I don't have a question of you. I do think that most of us, or at least I, agreed with the vote on the signage. The problem is I need some answers on what we can do, what's happening actually, and what we can do. We keep talking about Jeff Viken changing or ruling on the distance between signs. Is anything in litigation right now before Jeff Viken?
Yes, there was a court trial at the end of last year regarding the spacing requirement that you're referring to, as well as damages that Lamar said it was entitled to. That is now pending in front of Judge Viken for a decision, which I'm not sure when to expect that. I don't expect it tomorrow, I guess I'll put it that way.
Is it expectable in a reasonable amount of time, like months, or is it?
I would say months, but he's kind of notorious for taking a while,
Yeah.
respectfully.
No, I know him. And does the code, is this in 100% compliance with the code now, the proposed sign?
Well, with regard to the spacing requirement, well, yeah, I think that's why Robert recommended approval, because it does meet the height, size restrictions in the code. There is an exception for spacing for off-premise signs, so that if you fix them up or replace them or whatever to encourage, constant maintenance of the sign or improvement of the sign, so they're not deteriorating. There is an exception regarding the spacing requirement that's in the code now, and that's what was applied in this case.
Okay. According to the memo we received from you, Carla, I think it said it would be unwise to deny this request. Can we vote no? Is it legal? If we said no, will it be no?
Well, what I would say is that I would not recommend at all basing your decision on part of the ordinance that has been struck down by the court. I appreciate that the initiated measure passed handily at the time, but that has been ruled as an illegal prohibition on signs, which I think Jim Peterson mentioned. We do have the ability to regulate signage, and the court specifically mentioned that, but we do not have the ability to prohibit signs. So I would reiterate that it would be really unwise to deny the application if your basis is the initiative that has been struck down. I think that to the point that was made that the matter should be delayed until the ordinance can be amended, I would not recommend that course of action either. The application came in under a certain ordinance, and the application should be considered in light of that ordinance. And if changes need to occur to the ordinance, which would be something that our office would be happy to work on, since Judge Viken's ruling last February, neither the public nor staff nor the council has directed anybody to amend our ordinances, but that is an option. We could regulate digital billboards and change our ordinances, but I would not recommend waiting on this application until that occurs.
Thank you.
Yes.
Andy?
Thank you, Madam Chair. I have a series of couple questions and a few comments. Carlo, I think you answered this, but maybe it's unclear to me. What is the risk of waiting? What is the risk of continuing this item?
Well, I would say even if you continued it, the ordinance which should be applied to Epic's application is the one that's in place today. And that's not going to change. I mean, even if we were to change it, in the future, the application should be considered based on the ordinance that was in place when it was received. I think Sioux Falls is going through that right now, actually. There was an article in the Argus Leader where they're putting a moratorium in place, but they have to consider the applications that have been received in the past. So it wouldn't change this particular application.
Okay, thank you. And then there was comment made that the existing sign is non-conforming, but maybe this question's for you, Vicki. I would probably suggest that it's a legal non-conforming sign. Would that be correct? Because at the time it was built, it was in conformance, therefore it maintains conformance until something major happens. Is that correct?
I actually don't know the history, and Brad's not here today. He's our sign code officer for the city. But yes, it was during the review identified that it is legal non-conforming today to height and distance. And I don't know the history about when that came into place, but yes.
Okay. And then there was also comment that we're replacing, I'm going to rephrase, to a legal non-conforming sign to another non-conforming sign. But what you're suggesting is what they're bringing about today is conforming with the applicable code that we have within our statutes within the city today.
Yeah, that's correct.
Okay. And so on the spacing issue, going to the legal non-conforming side of this, if there was a spacing issue that increased it from 350 feet, I believe is the current distance, to 1,500 feet, the existing signs that are within 350 feet of each other would still be considered legal non-conforming. Is that correct?
Correct.
Okay. So that issue goes away. This is my opinion. My opinion is that the law says for the state of South Dakota that billboards that are light emitting are allowable. And I think that handcuffs our citizens' initiative. Unfortunately, it appears that we got it wrong. We got the sign amendment code ordinance wrong when we did this. So I believe in the voice of the community, but I think what needs to happen is the community needs to go back and they need to recreate a sign code that's within the laws of the state. So we got a little bit too far off track. The laws of the state are saying, you got off track, you need to come back and do it again. So I don't know who's in charge of doing that, but it sounds like that motion needs to get fired back up. I don't know if that's council or for that staff, but with all the basis of Carla saying, it seems like the right decision is to allow this to move forward. I do have one other question. In Lamar's lawsuit signs, were they able to move forward with what they wanted to do since Judge Viking's ruling?
They did get permits for 6 of the billboard signs. Or, the last one, though, would have required a conditional use.
Okay.
And they have not submitted that one. They took the position that they were going to wait until the ordinance was amended before they brought in that application.
Okay. So with what they went to court over, Judge Viking ruled in favor of them. The ones that did not require conditional use, they have been allowed to move forward with those signs.
Correct.
So it appears to me the right decision here is to move forward with what's been, I think we have what do we have? What's it called?
Motion.
A motion. Thank you.
Yeah. Vicki?
Madam Chair, so currently we have an ordinance that says that if you have an off-premise billboard sign, it's allowed as a conditional use. When this current sign code was adopted and it prohibited those to be electronic digital signs, the court ruled that that prohibition was illegal and it said you can't do that. So based on that decision, we accepted this application, and we reviewed it through the same criteria that we would any other off-premise billboard sign. When a billboard sign comes before you, there's criteria within the ordinance that allows you to approve it with stipulations, or deny it. And you have to cite the criteria that you're looking at, which we spelled out in the staff report, for any of those reasons. Did it meet the criteria? Can you add stipulations to ensure that it improves meeting the criteria? Or does it just fail to meet the criteria and you take the position that you deny? That's separate from that court case. We're looking at this site today. If someone were to come in at another site, we would again bring that application before you as a conditional use. We would go through the criteria, and we would present to you whether or not we felt that it was or wasn't meeting that criteria. One of the things that Planning Commission does, and you folks do it so well, is you vet the issues. We've had other applications before you where staff's walked into this room and we've had a recommendation on the table, and property owners have showed up and they've had concerns with maybe the noise or some of the headlights or whatever, and in the course of the meeting, you've added stipulations to require that there be fencing installed. Was it required by ordinance? No, but it addressed some of the concerns from the neighborhood. And that's what you're being asked to do today by this group that's here representing the citizens of Rapid City. I've been taking notes as I've listened to each of them speak to see if there's anything that would factor in as a stipulation of approval. Two things came to mind. Well, actually there were three, but two of them may be a little hard to regulate. One, you were asked to add a stipulation that said that the total measurement of the sign be 250 feet, not just the message center, but the total measurement of the sign. The current ordinance as adopted states that it's the advertising message that cannot exceed 250 feet. It goes to view shed. One of the criteria that you have to look at is what's the view shed of this sign. If you feel that increasing it from 250 to 288 impacts that, you could consider that request. There was also a request that there be complete compliance on all signs if you're going to be allowed to do an LED digital billboard sign off-premise. That would be a code enforcement nightmare for the city. It might read nice, but it would be very difficult to enforce. The third thing was code enforcement on a regular basis. Again, that's putting it back on staff to go out and look at that on a weekly, a monthly basis, and the chances you're going to catch a violation while you're there would be slim. So again, I think that we as staff appreciate the fact that you listen intently to what the audience has to say. You take comment from the applicant as well as the citizens. And before you today is a recommendation for a conditional use permit with established criteria. Your options would be to approve it as it stands in the staff report, to approve it with additional stipulations as you've heard concerns from the audience, citing what criteria you are meeting by adding that step, or denying it. If you should deny it, you'd have to cite specific steps. Based on the ruling from the courts, our attorney's office has cautioned you that it would be difficult for the city to take the position to deny this if they are meeting the criteria for an off-premise billboard sign. Just wanted to clarify.
Thanks. Karen?
Thank you, Madam Chairman. I think we all know that this is an issue that is a difficult issue for us to vote on. It's a difficult issue for the folks who are working so hard to get the billboard laws changed. And I also understand that from a business standpoint, people want to have advertising. I am not an advocate of billboards, and I think everybody kind of knows that. I'm with Jan on that particular aspect. I think in places signage is good. I'm concerned about this one for the neighborhood. It is a commercial corridor, but there are neighbors to the west, and I did drive out there and drove all around to see what angle people would be looking at for this sign. And I did come down from the north side of Sturgis Road going down and saw all the numbers of billboards that are already there. And it does disturb me a lot. I think, as Andy was talking about, you know, our hands are tied with some aspects. We can't say no to the digital part of it, continuing it, and I think Carla's right. I think it'll be a while before that happens, and you'd have to continue to a date specific, and you'd still have to look by the application date that they went by. So we're still stuck in that regard. So I don't see us denying it. I don't see us continuing it. But I do think, based on the fact that this is a conditional use permit, we do have a chance to make some conditions and some additional stipulations. I think the one that allows, reduces that sign at least down to a maximum of 250 feet for the entire sign, not just the face of it. I think that's something that we can do, and that will help a little bit alleviate some of the issues. I also have a concern about the code enforcement part, and I have turned in numerous signs that don't meet the criteria, and it's very difficult once you have that sign up there, once you have that digital sign, to have people scrolling and have flashing, and that disturbs me a lot. And I understand that somebody had mentioned that they're not in compliance now. How do we go forward and make sure that these signs are in compliance? And I look to the people who are doing the signs, and it's not just Epic, it's Lamar, it's not, I'm not pointing a finger at anyone specific, but if the sign companies would abide by our criteria and the ordinances that we've got, and they stand up and say, this is what we're going to do, and then they don't. And that disturbs me a lot. It's a bad name for the sign companies, as well as it's an intrusion into our space. And so I don't know how you deal with that. I'd like to see the city council help the sign codes a little bit, and maybe have some new codes, regulations done. And I would like to see them beef up the code enforcement, at least for signage, if there's a way to do that. So I'm kind of looking to you, Amanda, to carry that message. But for me, I know that there's a motion on the floor. I would like to add the stipulation about reducing that sign so that the overall dimension is 250 square feet, not just the advertising space. And I don't know if the motioner wants to add that as a friendly amendment, or if I want to make a substitute motion, but I will do either. So I'll let some other folks talk before I do that.
Dennis?
I would like to hear from Mr. Casey first before I make my comments. I believe he has a request form.
Thank you, Brendan Casey, Epic Outdoor Advertising. I do have to correct Ms. Bullman. We have been in compliance with every version of every sign code we've operated under for a decade and a half. When you switch the sign code every 10 months, you're always going to be in non-compliance, which is part of the reason you've attracted the litigation you have. As Ms. Fisher and Attorney Cushman have told you, there are some outstanding issues, but you're not likely to prevail on those either. What I have applied for is 100% within your existing sign code. There has been 0 comments from every neighbor that was contacted. You've got people here from West Boulevard, you've got people here from Robbinsdale, but these are the same people that got you in the first round of litigation. In regard to Epic not operating their signs in compliance, we are 100% in compliance with the permits we got when we put in our initial LEDs. Those were put in under a public purpose component, no different than the Civic Center sign. An additional component with that is we do public service, and a lot of it, close to $150,000 a year. So I would ask you to approve this permit And let's not rewrite the sign code every time somebody applies for a permit, which is what this city has done. So, thank you.
Thank you. Dennis?
Vicki, what is the status of our development of the sign code that would be in compliance with the state law? And rather than waiting on Judge Viken, can we take a proactive approach? How long will that take for that to be considered as a new ordinance and go through the council?
Well, remember, the city attorney's office hasn't decided if they're going to appeal this decision, so it would be difficult to appeal it if we're in the process of amending the ordinance. It kind of gives a contradictory message back to the courts. In the meantime, though, and assuming that at the end of the day we will be revising our ordinance to address electronic, digital, off-premise billboard signs, whenever we've done sign revisions to this ordinance, because of the interest from the community, there's always a request to the council that there be a committee formed. You have representatives from the sign company and from the individuals that you see in the audience here today, and there's a lot of good discussion that takes place. That typically takes around a year to get through all of that. Just as a thought, since you have professional planners and attorneys who write ordinances and enforce ordinances on a regular basis, I don't know of a time when it's just been staff who's looked at something and said, why don't we take a professional shot at doing this? We would then open it up for public comment, let the sign companies and the citizens all look at it. That's certainly going to be our request if it is the direction that we, sooner than later, amend our ordinance to address the digital billboard off-premise signage. But it would be a very lengthy period of time, I would assume, even if staff were doing it because of the public input.
Well, this has been an issue that we've had for many years, and it's had some legal questions asked, and it's gone to the voters. Why can't we come to a process that's proactive, that listens to all these people? And I think we have over the past years. We've listened to them, both sides, the professionals and the concerned citizens. But for some reason, we haven't been able to put things down for an ordinance that we can live with as a compromise ordinance. So at this point, I'm willing to say, let's continue this application, even though it's legal. It's therefore going to force us to write our revised signage and create an ordinance. Maybe that will get us off the center that we are currently seem to be on. But we have to do something. We can't just let this go for another year, 2 years, and just because we have issues from one side or the other, we have to make some decisions. And they're always appealable. I know that. You can appeal anything. But I think we either have to take what we currently have and say that's what we're going to live with, or we're going to set a timeline of 3 months and try to get something done. Thank you.
Amanda?
Thank you, Madam Chair. I'm not a voting member of the Planning Commission, but I do represent the City Council as liaison, and so I know that we'll have our shot at this issue when it comes forward, because I believe whatever decision you make, it will be appealed to City Council one way or the other. So with that being said, I do have a couple questions that I'd like to raise just from listening to the, may I ask some questions,
Please.
Madam Chair? Thank you. Carla, so what's before us is a petition, an application, based on the current ordinance. Based on the current ordinance, this sign fits the criteria outlined in our sign ordinance. If the city were to appeal the decision and the court then comes back and reverses the decision, this sign would be in jeopardy of having to come down, or with this sign being approved on that ordinance today, does it stay in non-conformance going forward because it was dealt with at the current ordinance? Or is there a stipulation we can put in, or the Planning Commission can put in, that if this sign is approved today with the court case still outstanding, whether it's appealable or whatever, that if the decision is reversed, it comes down?
That's a good question. I believe when the voters passed the billboard ban, it was only prospective. It did not require digital billboards to be taken down. It was only as to future billboards, digital billboards, and there's legitimate legal reasons for that, specifically taking of private property by the public. So I haven't looked at your specific question, Amanda, as to while a legal issue is pending in the courts, if you take action, if you're entitled to say we were legal nonconforming before, or we were approved, and so we would continue, be allowed to continue. I haven't looked at that specific question, but I think what I would recommend is that you assume that if this digital billboard goes up, pursuant to your decision or City Council's decision, and if the ban is upheld ultimately, that this billboard will be allowed to stay. Not having researched that legally, I might take a different position if I were to, but I think you should operate under that assumption today.
So just to clarify the question at hand then, because staff has said that other stipulations can be considered to be put on this, if the approval by the Planning Commission were to be made today, could the stipulation include that based on appeals, if the decision is reversed on this sign would be taken down based on court decisions, final court decisions?
My concern about that is that the sign company is going to expend a lot of money to put the sign up. And if we say you need to take it down later, I would be concerned about a takings claim. But I haven't specifically researched this legal issue. Maybe Mr. Sabers has, probably he has an opinion. But I wouldn't recommend that stipulation now based on that, but I definitely would look more into it before council.
Thank you. And then I know the planning commissioners would like to see city council work on some ordinances, but just want to clarify what was discussed here today is even if the city council were to change the ordinance, this specific application is still under the current ordinance. So this current application would not be applied to any future changes in ordinance. Like if we worked on an ordinance for 3 months from now, this application can't be continued and wait until we change the ordinance and then consider under that new ordinance.
Yeah,
correct?
I wouldn't recommend that.
So
yeah, I think it needs to be applied. The ordinance in place when the application came in needs to be applied.
And Carla, my understanding as a city council representative is that the appeal or the question of either side, Lamar or the city, appealing the current decisions, because there were multiple considerations that Judge Viken are looking at, that we're waiting for all the decisions to come in to see whether the city or Lamar wants to appeal, and if appeal is initiated, what specifically is being appealed at that time. Isn't that a fair assessment of why we're waiting?
Yes, you can't appeal until the whole case is final. The whole case isn't final until the judge has ruled on all of the issues. So the decision whether or not to appeal is down the road once we get the final judgment from the court.
Okay, thank you. Number 2, and I don't know if staff knows this, or we may have to direct this to EPIC or one of the representatives from EPIC here today, but all those other signs within that 1,500 feet, because the 1,500 feet separation of signs is currently in our ordinance, correct? Does EPIC own any of those other signs within that 1,500 feet of either side of this current sign? No? Okay, so all the other signs contained within that 1,500 feet on the circular of this one sign has an application today, there are no other Epic signs contained within that area?
No, all the signs there are grandfathered in, and the exemption was put in the code on spacing, so that would give incentive for companies to downsize, repair. The problem you have now with the existing code is that it's got zero incentives for us to downsize boards that, quite frankly, I'd like to, but I'm not going to go all the way down to the smallest size on a lot of them. So your code, and again, keep in mind, I think the code was 34 pages thick at one point. To give you some scale, your strip club ordinance was 14 pages thick. So we keep adding on more code and removing any incentive for the industry to touch anything. So I don't know if that answers your question.
No, it doesn't. So
Okay.
thank you for coming. Let me bring you back around again.
Okay.
From the sign that is currently has an application before the Planning Commission today.
Right.
Within 1,500 feet in a circular area all around there, does Epic Sign own any of the other billboard signs within a 1,500 foot of this sign being applied today?
No.
No. Okay. So then let me direct a question to staff then as a follow-up. So based on our current ordinance, if a special use permit is being applied for today on this one sign to go LED, if another sign within a 1,500 foot of this one comes before, would the 1,500 feet encroachment be a reason to deny any other LED signs or digital conversions of existing signs?
If they meet all other design criteria, height, size, setbacks, then the separation is no longer an element of review. That's exempt from review. The intent is to take some of these older billboards and replace them with new face. What wasn't considered at the time the ordinance was adopted is that some of these would be digital, and obviously the reason for the discussion today.
Okay, thank you for that clarification. And then the only other point that I wanted to bring up, and I'll ask staff this too, when we were talking, and I believe at the time, this goes back a year or so ago, we were talking about an on-premise sign, I believe. But I think the same thing can be applied to an off-premise sign. And that was the consideration for the residential properties within this area. And the topic was brought up that a stipulation could be instituted that at night, the light infusion could be dimmed, or it could be put on timers. Is that a stipulation that could be added to this sign in consideration of the residential districts that actually can view this sign or view the illumination of this sign?
The short answer is yes. One of the specific criteria for this conditional use is the impacts upon nearby residences. If it is the finding of this planning commission that they would prefer to allow the sign, but place limitations to limit the night impact on that nearby residential development, they could add a stipulation.
Thank you, Madam Chair. Those are all the questions I have at this time.
Steve?
I think based on what our attorney's telling us is today we have to go with the ordinance we have in place today. And I don't think the city council has to wait for a final decision for regulation. I think Viking said it pretty clear. You have the ability to regulate, not ban. So this doesn't stop our city council from moving forward because the public has spoken and they've said that we want some changes made. And we as a planning commission can't make those changes. Our charge today is to look at what the current law is and apply that current law to this with maybe some of the stipulations that we have here. So I think we should probably do that. Let's take a look at that. If there's some stipulations, let's address those and then send us on to city council where city council can address the future issues as far as regulation. So I guess if there's going to be some stipulations, let's get this going and let's move it on to city council.
Karen?
Thank you. I would like to make a substitute motion to include a stipulation that requires the sign, overall sign, to be 250 feet, not just the sign face. And I think that's a good comment that Amanda made, to also add a stipulation that the light on the sign at night, when the nighttime darkness, and I don't know that you need a time frame or not, but say, I want to go put a time on that because I don't know how to do that for sure, but if they can reduce that light to a nighttime lighting, I would make that a stipulation. So I'd like to add those two stipulations to the motion to approve this conditional use permit.
Is there a second? Andy?
Generally speaking, I'm in favor of Karen's stipulations, but then they raise a couple more questions, and like Steve, I'm ready to call the question here. But if the code says the message center can be 250 square feet, and if we say that the whole sign can only be 250 square feet, are we in compliance? I mean, is that something we can stipulate? That's question one. And question two, we can say turn the lights down at night, but to what? What level is acceptable? I don't know. I don't know that anybody knows what acceptable level. So I think they're reasonable stipulations. I just don't know how we reach a conclusion that's reasonable. So, Carla, on the 250.
Well, I think I would agree with Vicki, what Vicki has said, that this is a conditional use, and you are free to place additional stipulations based on the criteria that you're supposed to consider. One of those criteria would be the lighting, and one would be the size of the sign. And if you determine that it's appropriate for the area that the size of the sign be somewhat smaller than what is proposed, or that the lighting be somewhat affected, I'm a little concerned about the lighting provision, because I feel like that's a kind of technical requirement that I'm not an expert on, and I'm not sure that anybody on the commission is either. So I'd want a stipulation that's clear for the applicant and clear for the city. But as far as those sorts of stipulations, I feel like those are completely appropriate.
Okay, thank you.
Vicki?
Yes, and just for clarification to the motion maker, if you're going to add a stipulation, be sure to cite the criteria of review, noting that it is based on this criteria that you're adding it. I agree with Carla. It would be difficult to come up with terminology today to speak to the dimming, but I will turn to the applicant. I know that others have put timers on them. We have had some convenience stores in residential areas, and they put a timer on it where they dim at dusk, and then it goes brighter at dawn. Is that doable for you? Is that something that you would consider doing at this location? If you could come to the mic. And thank you, Brandon, for considering this.
Hi, Brendan, Epic Outdoor. These signs do that automatically already. As far as light pollution goes, these things don't spray light everywhere. Frankly, the board that's there now with the 400-watt exterior mounted metal halides is far worse, lighting-wise, than an LED. They're automatically timed with a photocell dimmed down at night. And if you watch any of them around town, that's what they do. So I don't see that as a big concern. And we've never got complaints on it.
Madam Chair, if I might follow up. So obviously, some of these that we ask them to do additional reduction in the dimming are those that don't have other competing light components in place.
Right.
Where it's not in an established commercial corridor yet, and that would be Catron Boulevard. There's some dark areas along Pennington County Fairgrounds. Everyone is concerned that that sign is too bright, and it's actually not, but there's no competing light to diffuse the impact of it. So based on what you've said today, with the lighting that's there, this will emit a lower level than what the current lighting has in place.
Yes.
Is that correct?
Jan?
Thank you. As to the other stipulation, the difference between 250 square feet and 280 square feet is not that great. And does that stipulation allow Epic then to have a 250-foot surface that is completely message with no trim? And is that a desirable way to look at billboards? So I just don't know that, I don't know that that accomplishes very much. Thank you.
Okay, I don't have any more requests to speak. Would you read, Karen?
Listening to the comments and I appreciate Brendan coming up talking about the lighting. I would definitely take that off the table. I think for us, it is difficult to pass this based on all the comments that I've heard. As a conditional use permit, I'm looking for anything that will help reduce the electronic billboard as an impact on the neighbors. And I think by reducing the size of the face of the sign or the electronic down to whatever they can get it down to, I think is worthy. And we do have that ability to put that extra stipulation in there. So my motion, if I can rephrase my motion, is to approve the conditional use permit, but to allow, to add a stipulation that says the entire sign should be 250 feet, not just the face of it. And I'll see where that goes. But I think that will at least have a small mitigation. Might not solve the issue, but it does help a little bit as far as the neighborhood is concerned. And that's my biggest concern is you have a static billboard out there today that people are used to, and it has no light on it. You start putting lights on anything, even if it's a small dim light at night, the neighbors are going to see that. And if I can get that down as small as I can, that helps me in my ability to approve the conditional use permit. So I'm still going to make the motion to add that one stipulation.
Steve?
Madam Chair, could I ask a question of Brendan Casey, please? Brendan, you just heard the question posed by Jan as far as taking it down to 250 versus having the entire thing be message versus having the 280. What is your thought process on that?
Frankly, I just think it's a little more antagonism towards the sign companies. 288 is an industry standard nationwide. That is called the poster board. That's what all Lamar's are. That's what mine are. It does affect layout. Not to say we can't do it, but why would we? I think to be more symmetrical with the existing signs, 288 is what's produced. Very common in every city. There's no reason we shouldn't do it here.
I am no longer lit here, so I'm assuming Karen has another question because there's no video here.
Sorry, I do. I'm just going to ask a question of staff. If they would change the size of the sign itself in any way, that is part of the major amendment that would come forward to us? Okay. I'm going to withdraw my motion.
Okay, the motion's been read. We do have a motion on the floor. And do you want to state it, Vicki?
Yes, the motion on the floor is to approve the conditional use permit to replace an off-premise sign with the stipulations as identified in the staff report.
Right. Okay, the motion's made and seconded. All those in favor, please say aye.
Aye.
Aye. Opposed? Motion passed.
Madam Chair.
Yes.
For those in the audience, just a reminder that they have 7 working days to appeal this item to the City Council, and that needs to be submitted in a written format. And I'd also like to just mention that even though there may be some concern that this is establishing a precedent, each site will be looked at individually very closely by staff and brought forward to the Planning Commission, and the listed criteria will be reviewed each time and presented for you for additional conversation.
Thank you. Thank you. Item number 20.
Good morning, Sarah Hansel, Rapid City Planning Department. On October 23rd, 2014, the Planning Commission acknowledged the city's receipt of Jim Lee's final report and recommendations for Rapid City's Historic Preservation Program. The report included observations and recommendations for changes to the city's historic review processes, and the report also included a recommended ordinance which incorporated those changes. Item number 20 is to acknowledge the Historic Preservation Commission's response to the Lee report. This item is on the agenda by request of the Historic Preservation Commission. After reviewing the contents of the report, the Commission formulated a response which they presented at their March 20th meeting. And I believe the chairperson has submitted a speaker request to add any further comment that he would like to and potentially address any questions that you may have.
Jean?
Good morning. My name is Jean Olson-Kesloff. I'm not the chairperson, I'm just a speaker. Speaking here on behalf of myself as a Preservation Commissioner. You've received the response from the Commission to Mr. Lee's report. I would like to give a little background from my personal experience through the years as a Commission member. First of all, I would like to thank the city for finally recognizing preservation in Rapid City, which has been largely misunderstood. Hopefully, Mr. Lee's report will shed light on the importance of preservation in our community. While Mr. Lee's report identified issues facing the Historic Preservation Commission and preservation in Rapid City today, it failed to include the causes of these issues and the steps taken by the HPC to try and resolve them. The HPC has spent many years and well over $45,000 in grant money trying to put into place procedures that would help preserve the city's historic districts, while at the same time help property owners in making decisions in maintaining their historic homes and properties. It has organized activities for Preservation Month since 2007, given preservation awards since 2006, contacted the Board of Realtors regarding a disclosure statement when property is sold, participated in the annual Home Builders Show for many years, requested a preservation officer to be hired to help property owners with applications so their projects won't have to be held up because of inadequate documentation, and that minor repairs can be performed without having to appear before the HPC. Hired experts to write design guidelines for the West Boulevard Historic District and a comprehensive preservation plan for the city of Rapid City. Hired an expert for commission training and asked that the State Historic Preservation Office travel to Rapid City as guest speakers for City Council and the West Boulevard Neighborhood Association. Nominated properties to the National Register of Historic Places. Members have attended preservation leadership training, presented before City Council on who is the Preservation Commission and what do they do. Updated the 11-1 application, created a contractors list for property owners, created and sent postcards to all property owners reminding them to contact the city if their projects may need historic review or may be eligible for a tax moratorium. What the Commission has needed is support. The City of Rapid City has a long history of preservation issues. Previous administrations have threatened dissolution and had key experienced members in such fields as architecture, engineering, contracting, not reappointed in an effort to control its decisions. Been told to approve inappropriate projects and make others simply go away. So it was very disappointing, confusing to read this report stating the many shortcomings of the Commission. Also stating the city staff is burdened with the administration of lengthy and often contentious public meetings and inefficient review procedures, that applicants are faced with approval procedures that seem vague, cumbersome, and arbitrary, that staff is adequate to handle the customer service demands, that the Commission should offer public education and advisory assistance that we need, training in historic preservation, and public outreach methods that the city will provide. That said, let's move on to resolve these issues that are before us. The city has a wonderful wealth of historic buildings. Preservation and progress can coexist. We just need to be wise in our decisions. Thank you.
Thank you. Sean?
Madam Chair, just a procedural reminder. You're set to hold this meeting from 7 to 9. If this meeting goes over 9, as you approach it, you'll need a motion to continue the meeting past 9.
Thank you.
And what time is it?
52.
Well, there we go. Thank you. I am sitting here today and I'm looking at this whole situation that's going on in front of me, and I have been on your side of the podium very much. I'm the chair of the Historic Preservation Commission. And Jean brought up that we are vague, cumbersome, and arbitrary in our decision making, and I see some of the things that go on up here with the commission, and some of the questions that come before us are very, very, very difficult, because we're trying to take into consideration the individual person that is applying for these things, and yet we're also trying to take into consideration all of the effects on all of the properties that surround all of those things, and they're very difficult. Thank you for handling it in the way that you did. It made me feel better about some of the very contentious issues that we've come up with. And so today we've heard about billboards and signs, and now there's historic preservation in front of you, and add chickens, and we've got a trifecta on this whole deal. But the point is that a lot of these things, especially that have been brought up in the Lee report, there's a lot of factual inaccuracies that are involved with that. And so this report here is to detail in as simple a form as possible, in a response, some of those things that are there. Unfortunately, the Memorandum of Understanding, or the Memorandum of Agreement between the city and the state, was not signed again and was ineffective as of the end of the year. Starting January 1st, there is no direct involvement of the commission with any of these things. So this is what this report is there, is just to kind of outline some of those things with a response as things go forward. As the only board or commission or party involved that's actually had the Lee report delivered to them, that's where this response and our guidance came from, to come to you to submit this first. So there are things that have resulted in us getting to this point. Mayoral appointments have not necessarily probably been the best that they could be. The professionalism of some of the people on the commission has not been the best that it should be. The moving the commission to the chambers, I think, in our particular thing, was another bad mistake. These are things that I've discussed with the mayor and with other people. But the biggest thing is, as we move forward, is just understanding that where we're going with this ordinance is not dissimilar to what you're dealing with signs and or any of those things that have impact on properties that are far greater than the property in question. Same exact thing that we've just listened with the signboard. So I think in light of this other thing, code enforcement is a huge issue. Because one of the biggest reasons that I'm standing here before you is the Lee report, factual inaccuracies. There could have been all sorts of reasons in the Lee report and the factual inaccuracies, the bad decision making from other leaders in the community. Other things like that have happened, but we're sitting here right now with the point that there is no enforcement for anything that we do anyway. And I think that's an issue that does need to be brought up. A lot of the hullabaloo that's brought up on historic preservation is because people get caught. It's not because the people who actually did work with us had successful things to say about us. It's because people got caught being out of an enforcement and no ability to enforce any of the decisions that were made. So anyway, as you go forward, if there's any questions, as you go forward, this is all set up just to address some of those things that the Historic Preservation Commission has actually implemented and directly affiliated with some of the things that are brought up in the Lee report. So thank you. Are there any questions?
Karen?
Thank you. Before I make I have a couple comments, but before I do that, I think I'll make a motion to extend this Planning Commission beyond 9 o'clock.
Motion is made and second. All those in favors say aye.
Aye.
Opposed?
Thank
Meeting,
you.
Motion passed. Meeting will be extended as necessary.
Thank you. I have to say that the Historic Preservation Commission is made up of some good people who do like historic preservation, and I think their ability to make good decisions is based on whoever's on that committee or commission, just like it is with us. You know, you get good people and you'll have some good decisions. It's a difficult commission to be on because there are that contentious folks who want to do whatever they want to do with their property and people who want to preserve the property. So there's already that set up for a lot of people. But over the years, it's been difficult to have all the issues that the lay report wants to have happen without additional funding from the council, without additional staff support, and just having been in that involvement over the years, it takes money to make historic preservation, and I don't know that the whole community is necessarily involved in this. I think people want to see, like, the West Boulevard area and downtown remain to somewhat historic, but still be able to be usable, but they're not engaged in that, and that makes it difficult when a small group of people are trying to maintain that balance, and you have a citizen, say, come forward to a council that says, you know, I want to do what I want to do with my property, and that makes it difficult to have historic preservation continue. I think in the past, Historic Preservation Commission and the city has done a decent job. I know they're talking about having facade easements, and we've had those in the past. We've done some of those things. The commission has done training. They've been to the home show. They've put that on. They've had a Historic Preservation Month, which has come before everybody over the last several years, and they've tried to get the education out. They did go forward, and we hired someone to do the planning, comprehensive plan for the West Boulevard District. It didn't end up that way, but they spent 2 years working on that. So they try to get those things forward. It's just a difficult path. I would like to see, and I read not only this acknowledgement that we're going to approve today, just the acknowledgement, but I've also read the information from the state, and there's a couple issues that have concern to me, and one is continued staff support and support from the council for funding to be able to go out and educate the population in a better way, and there's always room for improvement to do that, but that takes money, and I think that's an issue. The other thing that has me concerned is the separation of the two boards. It's so difficult to find good people that have interest in historic preservation to be on one board, let alone two boards, and I don't know how that's going to pan out, but I know that over the years we've had trouble with that, and the state had mentioned in their letter that if you have two boards, you might have two sets of different guidelines and two different ways of looking at historic preservation, and that has a concern for me. If we're going to do historic preservation in the community, we really need to take a good look at what is it that we want to do, and not necessarily rely on this lay report, but find out what we want to do as a community. We want to have the historic buildings continue to be historic, so when people come to town, they don't just see a mall or just see a normal place, but they see something like downtown Rapid City, which is vibrant and has the ability to attract not just the residents, but the tourists that we see come through. And I think that more emphasis needs to be placed on historic preservation than is currently done, but I don't know where this stands. I'm not sure if there's an ordinance that's going to come forward before us. Is that true, Carla? Do you know?
Yes, I've been working with Brett Limbaugh and Sarah Hansel on an ordinance, as well as other staff on an ordinance that hopefully will be before you next month. I'm hopeful.
Okay, and so some of these issues that I'm concerned with I can address at that time then, is what you're saying?
Yeah, hopefully that will give you some more specifics. I would just say the ordinance that Jim Lee proposed and the ordinance that you will see have many differences.
Okay,
we
thank
can
you.
talk about it then.
I appreciate that, and that's just my comments.
Eric?
That last exchange was what I was going to ask, is when the ordinance might come before us, and if it's going to be exactly the same as the Lee report, because I don't want to see it that way. Thank you.
Thank you. Okay.
I move that we acknowledge.
Motion's been made by Dennis and seconded by Steve to acknowledge the report.
If
All
I
those
may.
in favor, please say aye.
Aye.
Opposed? Motion passed.
If I may, Madam Chair, just one more thing.
Yes.
Thank
Sorry.
you guys very much. What we do, and I'm on the other side of the dais a lot, sitting right in your chair, and we do listen to this, and we do really try to do this, and thank you for all of your efforts that you do in that as well. And as we go forward with that, the ordinance and some of those other things, I thank you for taking a look at all of these things, and I'm available for any questions. You can get a hold of me through Sarah at the planning department or anything like that if anybody has any questions coming up on that as the chair of the commission. Thank you.
Thank you. Any other items?
Yes, Madam Chair, we have a few discussion items. I'll make mine quick and then turn it over to Brett. The City Council approved the ordinance that created the Planning Commission to serve as the Zoning Board of Adjustment. That becomes effective May 1st. So at your May 7th meeting, if we receive any applications tomorrow, that's the submittal deadline for that meeting, you will hear your first item as Zoning Board of Adjustment. At your next meeting, April 23rd, we have a very short agenda. And it's our intent at the end of that meeting to do a quick training session on the responsibilities associated with the Zoning Board of Adjustment to help clarify the difference between a variance and a plan development, and to introduce to you a new staff report form that we will not only be using for variances, but for several other of our development applications. We're hoping that they're more user-friendly. So just note that at the end of Planning Commission, we'll go directly into that.
Thank you. Brett?
May I ask one question? In the bylaws, it said that our meetings would start at 7:30. Your response was that we're going to take that out of the bylaws and just say that we will meet as soon as we complete our first task.
I'll visit with Carla, but the intent is that Planning Commission meet directly after Zoning Board of Adjustment, but no sooner than 7 a.m., so that if there wasn't a Zoning Board of Adjustment, the public would know, just be here by 7.
Okay, so we will still start at 7.
Start at 7,
Even
regardless.
even if we have no other agenda
Yes.
items except the Planning Commission. Okay, that's
And-
what I needed. Thank you.
And that is what we discussed previously. I don't know how it got changed in the conversation, because that's what we had discussed.
Oh, nothing, Mrs. Karen.
Steve?
Vicki, at the last variance meeting, it was brought to my attention that we're actually going to have different staff. So really, you know, training's almost twofold. Are we going to continue to have the prior staff for a period of time as we make the adjustment? Because basically myself and Eric are the only two that are remaining from the variance board. And it's going to be a huge learning curve when you got an additional 7 people who've never met and don't understand the process, because it is a different process than the Planning Commission and the rules that you go by and the things that you follow. You have a lot more latitude there than we actually do here. A lot of times when you look at the approval process, when we've actually approved things for variances for customers or citizens, we've actually not taken 100% of what they've done. We've taken a portion of it, maybe modified it to push it through. So I'm assuming in the training, we'll probably visit about that a little bit.
We'll visit extensively about that, and actually, as Zoning Board of Adjustment, you have less latitude than sitting as Planning Commission reviewing a plan development because of this criteria set forth by state law. We're going to go through all of that. You've got planners sitting here that's been reviewing variances, some of us for 20 years. You're going to have the same staff looking at this. It'll get routed around to building inspection, to the engineers, to the fire department, and a whole other group of people, and you'll have one report presented to you. There'll be an official staff presentation each time, and I think that you're going to find it user-friendly and hopefully give you a good picture of what's going on, so it's not piecemealed to you as the meeting goes on.
Yeah, what I meant about more latitude, Vicki, is in that when we make the decision, it's final. So you're actually helping somebody, and your decision that day is final. You can rearrange it, and they can go back and move on with their projects. Not going to be passed on to somebody else. It's actually done, and they can move on. So
Absolutely.
I really enjoy it.
Very good. Thank you, Steve. And that's a good reminder, and we'll include all of that information in our presentation on at your next meeting. Thank you.
Brett?
Okay. I had one quick item to talk with you about today, and it's regarding plating. Back in 2012, we had the original Lee study on give us recommendations on things we could do to streamline the development review process, and so we ended up creating a number of ordinances, including a new subdivision ordinance, and we did significantly reduce the amount of time it takes to get through our various processes. There was one item that the second floor committee group talked about, and for those of you who are unaware of who the second floor committee is, it was a group of staff, developers, engineers, and so forth that the mayor had assembled to take a look at the recommendations in the Lee report and bring forth recommendations. And so that when we were talking about plating with the committee, we had, as staff brought up, doing plating all administratively. There were a number of developers, actually, and or consultants who still wanted what was called a preliminary plan to come to the Planning Commission. Preliminary plan is essentially a sketch plat, a layout of what the eventual final plat would look like. Staff's contention was essentially if your plan meets the zoning ordinance requirements for lot frontage, lot area, if it meets the engineering standards for size of road, the infrastructure is put in place, if we brought that to you and they met all the requirements, you're really not in a position to deny it, nor would staff be in a position to deny it, nor for that matter would council ever be in a position to deny that plat. So we told them, if someone's going to voluntarily comply with all the rules that have already been established in our zoning ordinance, it is probably best for them to be able to come into staff and work with us on, say, a sketch plat. We can get them all the answers that they would need as far as access, size of road, so on and so forth. We can go back and forth with the sketch plat very quickly and nimbly. And once they are at a point where they feel that they've had all their questions answered and are satisfied with creating the final plat document, then they would just go ahead and create that final plat document. We would review it against the sketch plat and our rules, and if it complies, then we would go ahead and allow them to go down and record at the clerk and recorder's office. I'm cycling that issue back to you today. And what I'd like to do is go ahead and prepare some amendments to our plating ordinance and bring those back to you with a little bit more detailed and a better discussion of this than what I'm covering today, and then have you weigh in on that and see if it's something that you would like to amend. So today I'm just giving you a heads up that we'll probably be bringing something forward to you. And if you have any comments today, love to hear them before we start drafting.
Eric?
When you bring that back, can you bring back some of the, even if it's just on the, on the material linked to the item, some of the discussion, or whatever records exist of that second floor committee and the back and forth? Because it typically, developers don't usually ask to come in front of, the board, so I'd just like to see some of the reasoning if it still is recorded.
Yeah, and to get to your point, a lot of this was done off-site, and so we didn't record anything. It was essentially all of us sitting around a table spitballing, and then staff would go back and draft the ordinances, and we'd bring them back to this group, and they'd redline them, and we'd have this kind of back and forth. And this was the only issue that I think we didn't all agree on. However, I don't think there was a lot of resistance from them. History of that was, well, let's try it as a preliminary plan that has to go to Planning Commission for a while. And if, we find that all of them are getting approved anyways, maybe we should revisit it and just, have folks just go directly to final plat. So we're 2 to 3 years in now, and I'll bring the records of all the preliminary plans that you've approved. My guess is it's probably darn near 95, 98% of them that you've approved, if not all. So if that's the case, I think we can take the next step.
Karen?
Yeah, Brett, when this happens, my idea is that make sure that the public is aware of what's happening. And I know that we don't send out notices on plats and that kind of thing to the neighbors, but I know that there's been some platting that for people who live next door to plats, they don't realize what's happening. And so we have to be the ones that preserve that property and it's done correctly. So if there's a lot of changes that might come about in the process, I just want to know how that's going to affect us in what we do as far as making an approval.
Right, and that kind of gets to the heart of the point is if my neighbor is platting their property and they're doing it in accordance with the law, I may not like it, but you as a body really can't side with that neighbor and just say, you know what, you're right, because it's not a land use issue. All they're doing is creating a technical document that just lays out the street, lays out the lots, and we already have the rules on the book that says how they can do that. So it kind of saves you some agony having to debate that issue up here because, sometimes there's a number of neighbors that are going to come in and they're going to try to make this a land use issue, and it's not a land use issue. So we want to make sure that we're careful when we look at these things. And for that matter, council, because it gets appealed to council, and that's a bad position to be in.
Any other comments? If not, I'd take a motion to adjourn the meeting. Motion's been made and seconded by Karen to adjourn the meeting. All those in favor say aye.
Aye.
Opposed? Meeting adjourned at 9:14. I now have the longest meeting and the shortest.
This is the longest one that you've ever.
I know. I'm a record maker, aren't I?
Shortest memory.